Question 701. Wood frame houses, the material that is most commonly used for home construction in California, are most susceptible to damage by A. Wind, B. Rain, C. Termites, D. Coyotes. Correct answer is C. Termites. Strong winds can cause damage to any type of structure, including wood-framed houses, e.g., roof damage, fallen trees. Wood framing itself isn't inherently more susceptible to wind damage than other common building materials when properly constructed and maintained. Excessive rain can cause wood to rot and can lead to mold and mildew growth, which can damage wood framing. However, proper building design, flashing, and maintenance, like sealing and painting, can mitigate water damage. Coyotes are wild animals and pose no direct threat to the structural integrity of wood-framed houses. They might cause landscaping or exterior damage in some cases, but they do not damage the wood framing itself. The material most commonly used for home construction in California, wood framing, is most susceptible to damage by termites. Termites are wood-destroying insects that thrive in the relatively mild climate of California. They feed on cellulose, the main component of wood, and can cause significant structural damage to wood-framed buildings over time if infestations are not detected and treated. Termites pose a more direct and insidious threat by actively consuming the wood from the inside out. Question 702. Those parties judged to be incompetent and so without the capacity to contract include A. The insane, B. Minors, C. Those with guardians appointed by the courts, D. All of the above. Correct answer is D. All of the above. Individuals who have been legally judged to be of unsound mind or mentally incompetent are generally considered to lack the capacity to understand the nature and consequences of entering into a contract. In most jurisdictions, including California, individuals under the age of 18 are considered minors and generally do not have the legal capacity to contract. While there are some exceptions, e.g., contracts for necessities, their contracts are typically voidable at the minor's option. When a court appoints a guardian for an individual, due to incapacity, age, or other reasons, the guardian is typically granted the legal authority to manage the individual's affairs, including entering into contracts on their behalf. The individual under guardianship generally lacks the independent capacity to contract. Someone who is senile or intoxicated at the time of signing a contract would also be considered legally incompetent. Question 703. What happens to the agency relationship created by a broker accepting a listing if the broker dies? A. The listing remains effective. B. A new broker chosen by the broker's agency will assume the listing and the agency. C. Both A and B. D. The agency immediately terminates. Correct answer is D. The agency immediately terminates. The agency relationship between a seller, principal, and a real estate broker is a personal service contract based on the specific skills, knowledge, and reputation of that particular broker. The death of the broker makes it impossible for that specific individual to fulfill the terms of the listing agreement and their fiduciary duties. While the brokerage firm the deceased broker worked for may have other licensed brokers, the original agency relationship was with the deceased individual. For a new broker to take over, a new listing agreement would typically need to be negotiated and signed between the seller and the new broker, or the brokerage firm. The original agency based on the deceased broker's expertise does not automatically transfer. Therefore, the death of the broker who accepted the listing immediately terminates the agency relationship created by that listing agreement. The seller would then be free to list the property with another broker if they so choose. Question 704. An agreement that creates a leasehold estate which ends more than a year after the date of the agreement must be A. Recorded, B. In writing, C. Arranged by an attorney, D. valued at more than $1,000. Correct answer is B. In writing. According to the Statute of Frauds, which is codified in California Civil Code Section 1624, certain types of contracts must be in writing to be enforceable. One of these types of contracts is an agreement for the leasing for a longer period than 1 year, or for the sale of real property, or of an interest therein. Therefore, if a lease agreement creates a leasehold estate that will end more than 1 year after the date the agreement is made, it must be in writing to be legally enforceable. Recording a lease can provide constructive notice to third parties and protect the tenant's interest. It is not required for the lease to be valid between the landlord and tenant. There is no legal requirement in California for a lease agreement to be drafted or arranged by an attorney to be valid. While it's often advisable for complex leases, it's not a legal necessity. The statute of frauds for leases is based on the duration of the lease, not necessarily its monetary value. A lease for a term longer than 1 year must be in writing, regardless of the total rent amount. Question 705. A broker becomes aware that his listed property has large structural damage due to an earthquake that occurred 4 years ago. While showing the property to a prospective purchaser, the broker A must tell the buyer because the broker has a duty to disclose all material facts. B does not have to tell the buyer because his duty to disclose does not extend to the buyer. C does not have to tell the buyer because the house is being sold, as is. D does have to tell the buyer about the earthquake if the buyer is not aware of it, but not about the damage. Correct answer is A. Must tell the buyer because the broker has a duty to disclose all material facts. Real estate brokers in California have a fiduciary duty to their client, the seller. However, they also have a duty to be honest and act with fairness and good faith towards all parties in a transaction, including prospective buyers. This includes a duty to disclose all material facts that could affect the value or desirability of the property. Large structural damage from an earthquake is undoubtedly a material fact. It could significantly impact the property's safety, stability, and value, and a buyer would need to be aware of it to make an informed decision. Selling a property, as is, does not relieve the seller or their agent of the duty to disclose known material defects. As is generally means the seller will not make repairs, but it doesn't negate the requirement for transparency about the property's condition. Question 706. Which of the following would most likely appear as a credit in the seller's settlement statement? A. Prepaid taxes for the property. B. Tax lien on the property. C. Unpaid taxes on the property. D. Loan balance on the property. Correct answer is A. Prepaid taxes for the property. A credit on the seller's settlement statement means money is coming to the seller. If the seller has already paid property taxes for a period that extends beyond the closing date, they are entitled to a reimbursement for the portion of the taxes that cover the buyer's ownership period. This reimbursement would appear as a credit to the seller. A tax lien is an encumbrance on the property due to unpaid taxes. To provide clear title to the buyer, this lien would likely need to be paid off from the seller's proceeds, appearing as a debit. Any unpaid property taxes up to the closing date are typically the seller's responsibility. These would be deducted from the seller's proceeds at closing, appearing as a debit. If the seller has an existing mortgage on the property, the outstanding balance will need to be paid off at closing from their proceeds, appearing as a debit. Therefore, prepaid taxes are the most likely item to result in a credit to the seller on the settlement statement. Question 707. A title insurance company can insure the following: A. Lack of capacity to transfer title. B. Defective delivery of title. C. Whether the tenant's lease interest is free from encumbrances. D. All of the above. Correct answer is D. All of the above. A title insurance company can insure against various risks that could affect the ownership or marketability of a property's title. These risks typically relate to issues that existed in the public records before the policy was issued and were not discovered during the title search. Some common examples of what title insurance can insure include: A. Defects in the title. This can include errors or omissions in deeds, mistakes in examining public records, forgeries, undisclosed heirs, and other issues that could cloud the ownership. B. Defective delivery of a deed. If the deed transferring the property was not properly delivered and accepted, the transfer might be invalid. C. Tenant's lease interest. While standard owners' policies focus on the fee simple interest, specific leasehold title insurance can protect a tenant's rights under a lease against encumbrances or defects affecting the landlord's title. 4. Liens and encumbrances. This covers financial claims against the property, such as unpaid mortgages, tax liens, judgments, and easements that were not properly disclosed. 5. Lack of legal right of access. If the property lacks a legal right to access a public road, title insurance can provide coverage for losses resulting from this issue. 6. Lack of capacity of a grantor. As you mentioned earlier, if a previous owner lacked the legal capacity to transfer the property, e.g., due to minority or mental incompetence, the title could be challenged. It's important to note that title insurance policies have specific terms, conditions, and exclusions, so the exact coverage will depend on the specific policy. Therefore, a title insurance company can provide coverage for all the scenarios listed, although the specific coverage for a tenant's lease interest might require a specialized policy or extended coverage. Question 708. The horizontal piece supporting wall studs, to which the studs are nailed, is termed the A. Floor joist, B. Sole plate, C. Subflooring, D. Crossbar. Correct answer is B. Sole plate. The horizontal piece supporting wall studs, to which the studs are nailed, is termed the sole plate. Sole plate, also called a sill plate or bottom plate, is the bottom horizontal member of a wall frame. It rests on the subfloor or foundation and provides a nailing surface for the bottom ends of the wall studs. It also serves as the foundation for the wall structure, distributing the weight of the wall to the underlying support system, foundation or floor joist. Floor joists are horizontal structural members that support the floor and are typically located below the subflooring, not directly supporting wall studs. Subflooring is the structural sheathing that is attached to the floor joists and provides a surface for the finished flooring. The sole plate rests on the subflooring, or foundation. While crossbar is a general term for a horizontal piece, it's not the specific term used for the bottom horizontal member of a wall frame supporting studs. In framing, horizontal members between studs are often called fire blocks or blocking, serving a different purpose. Therefore, the sole plate is the correct term for the horizontal piece supporting and nailed to the bottom of wall studs. Question 709. The rectangular survey system is also called the A. U.S. Government Survey, B. Meets and bounds, C. U.S. Section and Township System, D. Both A and C. Correct answer is D. Both A and C. The U.S. Section and Township System, also known as the Public Land Survey System, PLSS, is a method of surveying and dividing land in the United States. It divides land into rectangular grids of townships and sections, primarily used in areas west of the Appalachian Mountains. Here's a breakdown. Townships. A township is a square with sides of approximately 6 miles, covering 36 square miles. Sections. Each township is divided into 36 sections, each approximately 1 square mile, 640 acres. Range. The north-south lines that define the townships are called range lines. Township lines. The east-west lines that define the townships are called township lines. Principal meridians and baselines. The entire system is based on a grid of reference lines, including principal meridians, north-south lines, and baselines, east-west lines. Section numbering. Sections within a township are numbered starting from the northeast corner and moving west, then south, then east, then north. Subdivision. Sections can be further subdivided into quarter sections, 160 acres, quarter sections, 40 acres, and even smaller lots. Question 710. Sophie, a college student looking to buy her first car, contracts with Danny to purchase his 1998 Yugo for $3,000. Upon walking to where the car is parked to transfer ownership, they see that the car has been completely vandalized. Its body dented, windshield smashed, wheels slashed. Sophie extends her sympathies to Danny, but tells him, under the circumstances, she will not be completing the transaction to buy the car. If Danny sues Sophie for not honoring their agreement, Sophie will probably A. Win, because both Sophie and Danny were mistaken regarding the damage done to the car. B. Lose, because Danny is not at fault that his car was damaged. C. Win, because it is Danny's fault that his car was damaged. D. Lose, because if Sophie had done a final check of the car before agreeing to buy it, she would have discovered the damage done by vandalism. Correct answer is A. Win, because both Sophie and Danny were mistaken regarding the damage done to the car. This situation likely involves the legal concept of mutual mistake of fact. For a contract to be valid, there must be a meeting of the minds on the essential terms and the subject matter of the agreement. In this case, both Sophie and Danny entered into the contract believing the car was in a certain condition, undamaged and transferable. The subsequent vandalism fundamentally altered the condition of the subject matter of the contract, the 1998 Yugo. This wasn't a pre-existing condition known to either party at the time of the agreement. Because both parties were mistaken about the car's condition at the point of transfer, the contract may be voidable. Fault is not the primary issue in a mutual mistake of fact scenario. The key is that the subject matter of the contract was substantially different than what both parties believed it to be. There's no indication that Danny was at fault for the vandalism. If the damage was due to Danny's negligence, the outcome might be different, but the scenario doesn't suggest this. The scenario implies the damage was discovered during the attempt to transfer ownership, suggesting it happened after the initial agreement. Even if Sophie hadn't done a final check immediately upon agreeing, the fundamental issue of mutual mistake about the car's condition at the time of transfer remains. The point of transfer is a key moment for the condition of the goods in a sales contract. Therefore, the most likely outcome is that Sophie would win the lawsuit based on the doctrine of mutual mistake of fact. As the car's condition was materially different from what both parties believed when they entered into the contract.